Hi, I'm Jules Epstein, Associate Professor of Law at Widener University School of Law in Delaware. People want to know what is happening in the Sandusky case, and the first stage, the one we're at now, I should say, is called a preliminary hearing. Let me explain what that is and what that is not. A preliminary hearing is exactly what its name says. It's a hearing that is preliminary to a trial. It is not a trial in that we find no one guilty or not guilty. A preliminary hearing is meant to determine if there's enough evidence to have a trial, and if there's enough evidence to justify whatever restraint on freedom follows when a person is arrested. For example, you may be arrested and given $1 million bail. A preliminary hearing would then answer the question, do we have enough reason to keep holding you, or should we let you go home? A preliminary hearing does not decide whether people are telling the truth about accusations, because that decision is made at the trial. The preliminary hearing asks a slightly different question. Crimes have elements, just like recipes have ingredients. At a preliminary hearing, for any crime the prosecution wants to bring Mr. Sandusky to trial on, it must show that it has some witness who can testify to each element. Simple illustration. One of the charges is that Mr. Sandusky sexually assaulted a minor. Someone will have to testify that there was a youth, that the youth was under a particular age, and that this witness saw Mr. Sandusky commit that sexual act. It may turn out that person's mistaken or lying, but the preliminary hearing only asks, are you willing to swear or affirm that that happened? If the answer is yes, and the person says that, then the judge at the preliminary hearing can say, okay, we now have not proof beyond a reasonable doubt, but what we call a prima facie case, a case that's on the face of it, on the surface, describes the elements of a crime and the probability that Mr. Sandusky is the one who committed it. The prosecution's goal is to make sure it can make out all those elements, but using the least number of witnesses possible. The prosecutor doesn't want to call all its witnesses, because then all it's doing is giving the defense a chance to hear them and to cross-examine them. So the prosecution, it's as in a card game, will show as few cards as is possible. The defense has a couple of strategies. It's going to be listening very carefully and going down that list of elements, the ingredients for each crime, because if a crime has 4 elements but only 3 are proved, the defense will ask that that charge be dismissed. The other thing that the defense will be doing is starting to evaluate each witness, to ask witnesses questions of that witness, to assess the witness's accuracy and the witness's credibility, and see how well that witness will perform if there ever is a trial.